Hey everybody, what's going on today? So, if I'm a little frazzled tonight, it's just because it's been one of those long nights. And no geek room. I'm not going to say all right, I'm not muted. Yeah. I was concerned about that. So today we finally have the filings from the Non-Sequitur show. So let's jump right into it, right? I know there's a lot of people out there who are ready. Damn, I got 41 people watching, so this is interesting. For those of you the first time here, my name is Nate. I'm an attorney. I'm a New York attorney, and I discuss legal topics here online. Now, it's interesting because this topic, particularly the non-sequitur show topic, I thought it was interesting because it's very rare as an attorney that you're able to just see a case develop as this one did. It developed from the breakup to the arguments to actually the court filings and hopefully to the disposition. So I've been tracking it all the way through, and this is just the next step in the process. We actually see the pleadings and see the everything. Hey everybody, hey, I see all the highs in there. So before we get started, I gotta give you a couple of disclaimers because I do not want to be sued by you crazy YouTubers. I don't want somebody talking about a lawsuit against me. So, the first disclaimer is this is a civil complaint. That means these are allegations. That means these haven't been verified. So, none of this could be true. Understand, this is a civil complaint, not a criminal complaint. The second thing is, these are allegations and not facts. These are allegations and not facts. So, in other words, Steve may say these are true, but these things have to be proven at a particular trial. So, again, these are allegations, and do not assume these are facts. And last but not least, the defendant has not responded. I think that's important because you're only getting one side of the story. And these things are written in such a way where the defendant hasn't had a chance to respond to any of the allegations. So you're only hearing one side of the story. So keep that in mind, too, as we go through the complaint. Nah, I'm probably going to weigh in on that later. So, here we go. Let's go to our complaint. All right. I hope the AC is the AC too loud because I have the AC going because it's way too hot in here. I feel like I'm about to burn up in here. All right. The meat and potatoes. All right. So this is a lawsuit, North Carolina and Guilford County. Is that Guilford County? Stephen McRae versus Kyle Curtis. Funny geek room. Funny. So, going through the complaint. Now, this was filed in August 23rd, 2019. It says plaintiff Stephen McRae complaining of the acts of defendant alleges and says. So, obviously, wherever it says plaintiff, that's Steve, and whenever it says defendant, it's talking about Kyle Russell Curtis. So first, the party. Steve McRae is from California, and Kyle Curtis is from North Carolina. Now, one thing you have here is I hear a lot of questions about, these guys are from different states. Well, you can sue someone from a different state if you go to where they're at. Steve is suing Kyle where Kyle lives in North Carolina. So he's going to where Kyle lives and suing Kyle in a North Carolina court. So this is appropriate. Now, if these allegations or if this case was above $75,000, Kyle could move the case to federal court under what's called diversity jurisdiction. Now, I'm not too familiar about the rules, but if you want to remove the case to federal court, you need a case in controversy over $75,000. So I'm not sure if Steve is asking for that much money, but if you're asking for or trying to get more than $75,000 and you have two citizens from different states, you can then go to federal court. Or you can, go to state court like Steve is doing. So right now they're in state court and Steve is filing. So I want to go to the end of the filings first because let's see what Steve is asking for. Let me see, Nate. That's true, right? So I'm going right to the bottom and let's see. This is what Steve ultimately wants from this lawsuit. So he prays for that the court enter a judgment against the defendant, Kyle Curtis, for the actual damages incurred by Steve in the amount of half the non-sequitur show's proceeds for the defendant's breach of the agreement. You got to prove there was an agreement. such an amount to be calculated pursuant to the non-sequitur financial documents held by the defendant and withheld from the plaintiff. That's the first thing Steve's asking for. The second thing Steve's asking for is an award, the plaintiff reinstatement of primary ownership and rights to the channel. So Steve wants the channel. Number 2. I'm trying to monitor the side chat, but it's going to be a little difficult. Number 3, Steve is asking to award Steve relief in the amount of excess of $25,000 on his claim for fraud. So just for the fraud claim, he's asking for $25,000 or in excess of $25,000. Number 4, he's asking for compensatory, and this is more or less just triple damages in the amount or excess of $25,000. So that could be up to $75,000 on the claim of unfair, deceptive trade practices against Kyle. So unfair and deceptive trade practices, he wants another $25,000 or more. And then an alternative, award the plaintiff relief on the claim of quantum merit, which we'll talk about. That's just, getting paid for work. And enter a judgment against the plaintiff for reasonable attorney's fees. You want those attorney's fees. Number 7 is for tax costs, fees against the defendant, maximum allowable law. So Steve wants both attorney's fees and court costs. Like, you forced me to take you to court, I want you to pay for it. And to provide, and this is number 8 is the catch-all. Everything else. And he submitted it the 23rd of August, 2019. So I'm going to look at the chat real quick to see if anybody has any questions. All right. Yeah, we got no real questions here. Just a lot of chatter. So I'm going to let you guys talk in the chat. So now we know what Steve is asking for. He's asking for more, like really what, like 75, almost 100 grand right here, plus a lot. So first, we went through the parties. Now we go through jurisdiction. Jurisdiction and the matter is proper. Well, simply put, I'm suing the defendant where the defendant lives. So you have jurisdiction. They have the proper venue because he lives there. So now this is the important parts, the background. Plaintiff, Steve McRae, independently operates a YouTube channel commonly known as Steve McRae. In or around December 17th. Now, one thing I always like to do when I'm reading these things is try to keep the timeline, because that's important. When things occurred is just as important as what actually occurred. So, December 2017, defendant, which is Kyle, approached the plaintiff via his YouTube channel and left a message about possibly creating or co-hosting a new online podcast for public entertainment. Plaintiff and defendant subsequently entered into a verbal agreement, the agreement, to create an air podcast episodes now commonly known as the Non-Sequitur Show, the podcast. So Steve is alleging that they entered into a verbal agreement to create and air a podcast. So we haven't talked about the YouTube channel. We're talking about they both entered an agreement for the podcast, the Non-Sequitur Show. Your face is on the copy. All right, let me go back. Sorry. Let me see. Oh yeah, I'm reading too high. Sorry, I'll read lower. Hey, I should have went back and looked at this. Sorry. That should be lower. All right, so now you guys should be able to read it. My face shouldn't be on it. Plaintiff subsequently entered into the verbal agreement, the podcast. So first we have early on, we just have a podcast, and they have an agreement to this verbal agreement. Now, two things that are going to have to be proven. You got to prove that you had an agreement, this verbal agreement, and you got to prove what it's for. Just because he said it, these are allegations again, doesn't mean this is actual. Prior to the launch of the podcast, plaintiff, Steve, approached the defendant to suggest expanding the business endeavor to include a YouTube channel. So this is very smart. Steve is now saying that, hey, our agreement was actually for the podcast, the show, the Non-Sequitur Show. And as part of that business agreement, more or less a subset of that business agreement is going to be the YouTube channel. So really the Non-Sequitur's podcast is the original agreement, and it seems like the YouTube channel is a subsidiary of that original agreement. The defendant's interest in co-hosting the Non-Sequitur Show, paragraph 9. Given the defendant's interest in co-hosting the Non-Sequitur Show on YouTube, as well as the plaintiff created the channel and by default served as the primary owner of the channel. So Steve created and he served as the primary owner. The podcast and the channel herein are collectively referred to as the Non-Sequitur Show. So Steve has done something which I think is Steve's attorney has done something very interesting. He's labeled the agreement part of the podcast. We have an agreement for a podcast. But as an expansion of the podcast, that agreement is now going to cover the YouTube channel. And now, when I say non-sequitur, it refers both to the podcast and the YouTube channel. Now, the YouTube channel, Steve says he was the one that initially owned it. But now, it's part of this conglomerate, the non-sequitur conglomerate. Oops. Sorry, I'm going back to the live chat. All right, so I was ending with number 9. We're going to number 10. Under the agreement, again, you got to prove, Steve's going to have to prove they had an agreement and the terms of that agreement. Right now, he's just saying we had an agreement, but it's just an allegation. You have to prove you actually had an agreement and what the terms were. Under the agreement, plaintiff and defendant would appear as co-hosts, so they're talking about what's happening with the show, and would have equal decision-making authority in regards to non-sequitur operations, airings, and would equally divide any potential proceeds deriving for the non-sequitur's financial success. So he's laying out what Steve believes are the terms of the agreement. Again, this would have to be proven. Now, if there's no paperwork, how do you prove it? Well, you put Steve on, and remember my video about the credibility of Steve McRae? And then you put the defendant on, and remember the video about the credibility of the defendant, because you got to try to figure out what are the terms of this verbal agreement. And that's the problem with verbal agreements. It's just like, you have to prove you actually had an agreement and what the terms were. And those are really, really hard to prove, especially when you don't know it. So going down on non-sequitur, plaintiff and defendant discuss various topics. So they're going about the show. Yeah, oftentimes special guests. So they're describing the show. Number 12, the primary owner, plaintiff had administrative rights. So Steve had the administrative rights, which allowed him to access the financial documents in the event the non-sequitur show became profitable. Now, they don't really put a timeline here. They're going about the beginning, but they really haven't put a timeline, because I think it's important where if Steve is saying that as primary owner, the plaintiff, Steve McRae, had administrative rights. So it seems like he could have seen all this stuff. So let's see when this stuff stopped occurring. So on or about December 31st, 2017, this is the day before New Year's Eve, defendant informed plaintiff that in order to establish a search engine optimization and maximize viewer traffic from the non-sequitur show videos, the plaintiff would need to release the primary ownership rights of the channel to the defendant. Again, this would have to be proven. I'm assuming Steve has text messages and stuff to prove this, but this would have to be proven. Relying on the defendant's representation regarding search engine optimization, plaintiff Steve McRae transferred primary ownership of the channel and accompanying administrative rights to the defendant. All right. So let me look at the chat real quick to see if there's any questions. No. If you want to put a question, you got to post my name up in there, at Nate Broady, and I'll be able to answer it. So we have now a little background about the show, about kind of how everything developed, the podcast. So they had an agreement about the podcast. The channel just happens to be an offshoot of that. Steve actually started the channel, and they are splitting everything 50-50, or Steve was under that impression that they were splitting everything 50-50. On number 15, on January 17th, 2018, Non-Sequitur debuted its first video on YouTube. On the channel. In or around July 2018, so we're talking about 7 months later, Non-Sequitur began profiting significant revenues. Stemming from advertising payouts, merchandise sales, donations, and several other revenue streams. So about July 2018, that's when they started making money. Shortly thereafter, plaintiff requested access to financial statements provided to the defendant from YouTube in addition to his portion of the non-sequitur's profits. Defendant asked plaintiff to patently wait until, on a whole nother year, April of 2019, so the defendant could first handle non-sequitur's taxes. So in 2018, I was like, let me get the financial documents. He says, wait, we're in April, or July, we're in July. Wait till next year, April. Um, because I'm going to handle taxes and I don't know. Again, these are just the facts as laid out as alleged by the plaintiff. All right, question. Would you be able to put the PDF when you finish this stream? Yes, I will. I will put the PDF when I finish this stream. You guys will actually have the PDF of how of all these documents. Matter of fact, I'll do something better. I'll show you guys how to actually get the documents. So when the file is updated on the court's website, you'll get access to the documents firsthand. Now, to do all that, I'm actually not going to do that in this stream. I'm going to do another stream. But we're probably halfway through this document. So I got to give my little pitch. If you haven't subscribed to this channel and you've watched all this non-sequitur stuff, stop now, hit that subscribe button, show me some love so we can make this thing happen. And thank you for your support. And don't forget, I got Patreon, everything. If you like this mic, click those Amazon links down below. That's right. I'm slumming here. Get those subscribers up. All right, back to the case. So here we go. Now, in April 2019, so remember, we were at June 2018. April 2000, I'm going to pay you, hold off till next year at April 2019 before, we talk, I show you financials, which is almost a year later. So April 16th, 2019, Steve waited, the 10 months. Plaintiff again requested his portion of the non-sequitur show proceeds. So now I've waited till April and I'm requesting my proceeds. Defendant stated that his accountant would contact the plaintiff soon. Defendant refused to disclose the identity of said accountant. That sounds familiar. Who the hell is the lawyer? Who the hell is the accountant? And plaintiff was never contacted. Again, allegations. I'm assuming Steve has something to show that these allegations are true. After multiple other attempts, plaintiff to collect the share of non-sequitur proceeds, the defendant informed the plaintiff of his intent to retain the entirety of non-sequitur show's earnings from certain revenue streams and stated that the defendant alone owned the channel, which we've seen through, my videos. That's Kyle's argument. I alone own the channel and you kind of were working for me. Now, one thing I think is very interesting. Here, Steve never tells in this complaint that he told Kyle to hold the money. He goes into this, he asked him for the financial accountings in April 2000. What is it? He asked him about it in July 2018. They started becoming profitable. He asked him about it, but they don't go into, he doesn't mention that he asked Kyle to hold the revenue for whatever reason. I don't want to get into the fraud thing because I know everybody's going to get into the fraud thing. But he asked Kyle to hold the money. Steve said that. But notice that he doesn't put that here. He's almost making it seem like Kyle just had the money all to himself and wasn't communicating with Steve. So it's written in a way, but again, this is written from the plaintiff's side to just kind of make it seem like Kyle just hoarded the money and didn't give Steve access. When, more correctly, Steve is on record asking Kyle to hold the funds. Question from the thing, Peanut Gallery. How would the situation, which gives a bad vibe about conspiracies, fraud between the two of them, get what in the way of this lawsuit? That's true. Don't forget, you better subscribe. You asking me all these crazy questions. You better subscribe. But don't worry, I don't know. I think there's a lot going on here, and I think the court just is doing what it needs to do. It's because again, this is just a civil claim. All that fraud and conspiracy, that would be in California. We're in North Carolina, so it's a little different. All right, so now so we're April 2019, nothing. Then he asked for, hey, give me my money, nothing. And the reason why he didn't get his money last year is because Kyle said he needed to hold off on everything for tax reasons for another 10 months. Believable? I don't know. But, that's kind of not what I'm getting. Paragraph 20. On July 11th, the plaintiff and defendant participated in a preliminary show, the pre-show, in anticipation of live shows which was ultimately posted by plaintiff on his separately owned YouTube channel titled The Death of the Non-Sequitur. During the pre-show, defendant expressed his intent to change the direction of the show and to strip plaintiff of his interest and rights in the non-sequitur operations moving forward. On the same day, defendant utilized his primary ownership rights to bar plaintiff from further accessing the channel in the plaintiff's capacity as non-sequitur co-host and as partner of the business endeavor. So Steve here is making it very clear. We're partners, I'm a co-owner, and he just shut me out. Hostile takeover. Question. Purple, I'm not saying that other word. Okay, moving on. Gotta refresh this. All right. So, paragraph 23. The defendant concedes that he owed plaintiff half of the proceeds of the non-sequitur show's various streams and revenue up to plaintiff's ouster as co-host of the non-sequitur show. However, defendant refused to provide the plaintiff with the same. Line 24. Defendant continues to refuse plaintiff access to the financial information related to non-sequitur's profitability. So here we kind of have this clear picture. Steve is saying that we started the podcast together. As an offshoot of the podcast, we did the YouTube channel, and at the original agreement, this verbal agreement, he makes it very clear it's a verbal agreement, was that we split everything 50-50 and we're co-owners of everything. Steve has explained what the terms of the verbal agreement was, that him and Kyle have 50-50 ownership, they have 50-50 admin rights, and that Kyle, by oustering Steve, has interfered with his rights, his ownership rights to the show and to his 50% of the proceeds, which is fair. So here are his claims for relief. So his first claim is breach of contract. Now, if you've watched any of my videos, you know this was coming. This is a breach of contract case. So it's a verbal agreement, number one. Now, verbal agreements are generally enforceable, but there are limitations, statute of fraud, some other things. So I don't want to say it's an uphill battle, but it's an argument that has to be made, because not only do you have to show we have an agreement, you also have to show that what the terms of the agreement are. And that's why it's very hard when you have verbal agreements, because then you've got to just rely on what people remember from 2 years ago, like this from 2017. Are you sure this was the agreement? Are you sure what the terms of the agreement were? And then you have to rely on their credibility. Have you said different things in the past? Or are you saying different things now? So it's not as easy, but first claim, they have a contract. So this line 25, breach of contract. The agreement was between the plaintiff and defendant is an enforceable contract. Again, predicted. Plaintiff fully performed his obligations under the agreement, which hasn't been proven, by appearing on the non-sequitur show, co-hosting and managing the operations of the non-sequitur show. So he's more or less saying, I acted as if I was the owner, and it's evident by our actions. Can't see the writing. Okay, let me see if I can make it so. Plaintiff, enforceable contract. Yes, sorry. Yeah, hopefully you guys can see it now. Breach, yes. All right. So going to line, where did I leave out? I was on 27, right? Yeah, 28. Defendant, Kyle's failure to provide the plaintiff with access to the financial documents regarding non-sequitur and his equal share of the profits serve as a violation of the terms of the agreement. Again, Steve has now said Kyle is violating the agreement, which we don't know, and Steve is saying he's violating the terms of the agreement. Now, Kyle has alluded to different terms. In his videos, Kyle is saying that the terms aren't what Steve is saying. So if Steve is saying here are the terms and Kyle's saying the terms are something different, how do you figure that out? Well, you get them on the stand and you try to figure out who's more credible. So, and then you'll by the actions too. Line number 28. Sorry. The defendant's failure to provide plaintiff with access to financial documents regarding non-sequitur equal share serves as a violation in terms of the agreement. You already read that. 29. Defendant's interference with plaintiff's access to the channel in his capacity as co-host serves as a violation of the terms of agreement. Again, these are all, he's telling us specific terms from an agreement 2 years ago. And one thing about this one, number 28, think about this. Defendant's interference with plaintiff's access to the channel in his capacity as co-host serves as a violation of the terms of the agreement. How? Because when they first initiated this agreement, they didn't have a YouTube channel. They had a podcast. So denying him access to the YouTube channel, I'm not too sure. But again, it's an argument. Last, pursuant to the terms of the agreement, again, a verbal agreement 2 years ago, they're just trying, he's remembering the terms. So this is the terms that Steve had told him the terms are. Maybe they have some text messages or something in writing to show what these terms were. But I'm just assuming, we haven't seen any of that now. So here it is, the terms of the agreement and the defendant's public statements. So he's relying on both the terms of the agreement and then saying, as proof, the defendant's public statements on the pre-show, defendant remains liable for the plaintiff for half of the non-sequitur show's profits and disclosures of the financial documents in association with the non-sequitur show's financial condition. The amount owed to plaintiff by defendant is in the sum of excess of $25,000. Plaintiff has fully performed his obligation under the agreement. So here we have an agreement. I performed what I needed to perform. Here are the terms of the agreement, and you should now find this enforceable and pay me my money, whatever that sum is. So that's his first claim, breach of contract. And if you know, we all agree to that. Second claim is for fraud. Woof. All right, so all allegations above, blah, blah, blah. So number 34, as an inducement of the plaintiff to surrender primary ownership rights of the channel, the YouTube channel, to the defendant represents to the plaintiff that defendant was required to obtain such rights for the purpose of establishing search engine optimization. So Steve is really harping on this. Like, I gave over the channel because he told me search engine optimization. And we don't have search engine optimization or something. I don't know. So, was that a bad reason? I don't know. Or Steve is more than saying, it seems like Steve is trying to allude to that he lied to him. Defendant's representation to plaintiff concerning defendant's need for primary ownership rights of the channel were false. Were made with the intent to deceive the plaintiff, again, an allegation that needs to be proven, and or were made with the intent to induce plaintiff to otherwise transfer primary ownership rights of the channel to the defendant so the defendant can acquire sole administrative control of the channel. Again, allegations that need to be proven with some evidence. Maybe he has text messages, maybe he has something, but he's going to have to prove this. I'm going to the live chat to see if anybody's saying anything to me. I'm just doing a cursory run. If I don't see my name lit up, I'm moving on. All right. So now we see this whole giving over the channel to Kyle was a big thing. Number 36. After defendant's acquisition of primary ownership rights of the channel, defendant excluded plaintiff from accessing the channel and ultimately informed the plaintiff that he intended to carry on the non-sequitur show without the plaintiff. That's in that video. I think this is a very well-written complaint. The false representations of the defendant were material and were reasonably calculated to deceive plaintiff into transferring primary ownership of the channel to the defendant. So Steve is really harping on that. Like, I gave him the ownership based on search engine optimization, and that was all BS. He deceived me. He lied to me. We weren't optimized for search. Like, it's an interesting argument, but I don't know. It's gonna, especially if you're 50-50 partners, then he should have had access to it too. I don't know. It's interesting. Upon information and belief, okay. Interesting. Upon information and belief. This is something that I don't really know, but I have some information and belief. Defendant knew or should have known that the plaintiff would not have transferred primary ownership rights. So Steve's saying, I would not have done this of the channel without the assurances of the defendant that such was necessary to establish search engine optimization. So Steve is saying this is the only reason why I transferred it, and that the plaintiff would not have transferred primary ownership rights of the channel had it known the representation, had it known, had he known, maybe I think it's the wrong pronoun, had it known the representations and assurances made by the defendant were false or made with the intentions of excluding the plaintiff from the channel's operations. Now, even though that's a typo, us lawyers aren't perfect, we make typos. If you read Supreme Court cases, there are typos. There are people whose careers are to read Supreme Court decisions and point out all the typos. So just because there's a little typo doesn't weaken the unless it's like a real material typo. All right. Make sure you guys can see this. Yes. Okay. Here, false representations of the defendant were made with the intent to deceive the plaintiff and with the intent for the plaintiff to act upon the false representation by transferring the primary ownership of the channel to the defendant. He's really harping on this. Plaintiff was in fact deceived by the defendant's false representations that primary ownership rights of the channel were to be transferred to the defendant for the purpose of establishing search engine optimization. Defendant has suffered damage in the amount of excess of $25,000 to be determined at trial. $25,000 because he lied to him to get ownership rights to the channel for search engine optimization. Is that worth 25 grand? Let me know in the comment section. All right. No questions for me. Nate Broady. Does it look like Steve is... Yeah, I think this one is a little swinging for the fences. This one is swinging for the fences. Yeah, I think he's swinging for the fences. Nate Broady, I am wondering how any person not representing YouTube can claim ownership of a YouTube channel. Well, he's claiming ownership of the rights to the channel. So that's what he's claiming. Unless, yeah, so he's claiming ownership rights. He's saying that that YouTube, and technically you're right. We are licensing the channels in a certain way. YouTube is really the owner of the channels. That's why they can take them away when they want. So, but YouTube is giving that right to Steve, and Steve, by having that right, can then sell it or do it. That's why people sell YouTube channels all the time. So it is something it's something tangible that you have. Last question before I move on. I'm wondering how any person... Oh, yeah, that's the same question. All right, moving on. So, plaintiff... So he wants $25,000 for fraud. And that fraud is, you told me I needed this for search engine optimization, and I didn't get it. Next, the third claim for conversion. Now, conversion... Let me get the legal definition, because I know what it is, but I don't want to mislead people, because I know it's different in New York. Because I know conversion is an intentional tort. Hold on. Yeah. All right. So it should be the same everywhere. Conversion is an intentional tort where you're taking something and, well, I'm just going to read it. It's an intentional tort, taking something with the intent of exercising over the chattel and ownership inconsistent with the real owner's right of possession. In other words, it's me taking something from someone and saying I'm the owner, but I'm really not the owner. That's with conversions. It's an intentional tort where you have to prove the person intended to do it, intended to take your property and pretend that it's his or hers to have ownership of. So that's what this third claim is about. The agreement and the subsequent behavior of the plaintiff and defendant memorialize the existence of a general partnership. First time we've heard about partnerships, general partnerships, anything like that. We heard about an agreement. Now we're talking about a general partnership. Creating a fiduciary relationship. Fiduciary relationship is, the best way, it's an obligation to be faithful to the business, to do the right thing. You know, I could look up the legal definition, but that's generally what fiduciary relationship is. If you're a business, you're going to do something, you know, you're not going to steal from the business. That's really what fiduciary is. It is an obligation of you to act morally with the business. You know what? Fuck it. You're here. Let me just look it up. It's funny because I use these words all the time, and it's hard. It's one of those things where you use the word so much, and everyone who you generally use it around, we know what the word is, but then when you have to kind of define it, it's hard to just say, okay, this is really what it is. But this is what it is. It's a person who holds a legal or ethical relationship of trust with either a corporation or even in some type of venture. So, and by law, if you have a partnership or you're in a corporation, if you're acting as an officer or someone who, for that corporation, you generally would have a fiduciary duty to act in an honorable way, an ethical way. So that's what Steve is saying here, is that based because they had this general partnership, Kyle then also, by law, had this fiduciary relationship that he owed to Steve. Oops, go back here. Probably meant plaintiff by defendant. So here, the agreement and the subsequent behavior of the plaintiff and defendant memorialize the existence of a general partnership. We've read that. The agreement provided that the plaintiff and defendant would equally share, distribute of the profits deriving from the non-sequitur success. Again, we're talking about the agreement again, and now they're talking about a partnership. Now, it seems like, now from what I've been reading, again, I don't practice North Carolina. I'm not familiar with North Carolina law, but from the things that I've read, my opinion, it seems like in North Carolina that you can have a partnership without writing, but you'd have to prove a couple of things, like, what the terms of the partnership is, who's involved with the partnership, that type of thing. And generally, it's hard to do that. That's why most people have written partnership agreements. But Steve is more or less seems to be saying we had a general partnership, and this general partnership is going to be evidenced by the way they were acting, by these verbal things that they were doing. But there was actually no writing. But the court can find, if the court finds that they did have a general partnership, this one that wasn't written down, then based on the fact that they had a general partnership, then Kyle would then have this fiduciary responsibility to Steve to act ethically. And Steve is saying that Kyle didn't do that. The agreement provided the plaintiff and the defendant would equally share, or we read that, line 45, by refusing to provide the plaintiff with an equal share of the non-sequitur profit. The defendant interfered with and deprived the plaintiff of his right to possession. But again, I can see right now what Kyle's going to say. He's going to show that clip of when Steve asked him to hold the money. Yeah, Steve told me to hold the money. So I didn't, I didn't interfere or deprive him. He told me to hold it. So again, interesting piece. We'll see what Kyle comes back with. Defendant, through his actions, has exerted an unauthorized assumption and exercised right of ownership over plaintiff's funds to the exclusion of the plaintiff. Now, I think you can say that later, maybe. But early, again, I don't know how you get over the hurdle that you told him to hold the funds. It's like you told him to hold the funds. You said you told him to hold the funds, and now you're saying that he was holding it unauthorized. I don't know. It's something that I think would be hard to get over. Defendants, he's asking for another $25,000. Is it worth $25,000? I don't know. We'll see. Fourth claim. Oof. Are you guys getting bored? I feel you guys might be getting bored with me. All right, no questions from the peanut gallery. How long does Kyle have to respond now? If this is saying this was August 23rd, so he would have 20 days from that. But I'm not sure if he has responded or not. I think you'd have either 20 or 30 days. I'd have to look it up in North Carolina to see, but 20 or 30 days generally. All right, fourth claim, breach of fiduciary duty. So now Steve is, and again, this is brilliant. Build it up. Yes, we had a general partnership. Yes, we had this. Yes, we had this. And now, if the court finds we had a general partnership, he breached that fiduciary duty. Here comes Steve again. The agreement and the subsequent behavior of the plaintiff and defendant memorialize the existence of the general partnership, just like I was saying before. They're saying the behavior and this verbal agreement, we got a general partnership, creating a fiduciary duty between the parties. And he quotes the general, then he quotes the law. I literally just said that. Defendant breached his fiduciary duty to the plaintiff by converting, see the last one, and misappropriating the plaintiff's share of the funds to his own personal use, or otherwise depriving the plaintiff of the same. So again, I think Kyle's response to this is, didn't Kyle, I remember I was watching one of Steve's streams, and Steve said Kyle asked him if he can use some of the money to pay his rent or something like that. This is what I remember. I could be totally wrong about that. And if that's the case, then, he did allow Kyle to use that for that. And then I remember, again, the other part is he did ask Kyle to hold the money. See, I'm still trying to figure out how you get over that hurdle. Because remember, it's Steve's own words. Steve is the one that said he asked Kyle to hold the money for medical reasons, whatever that meant. But that's something that you'd have to get over here, because here he's saying that Kyle's just holding the money, not really alluding to the fact that he initially asked Kyle to hold the money. Now, I do agree, after he asked for the money back in April of this year, then yeah, that's a different story. But before that, you can't really make that claim because you told him to hold the money. They said Kyle has 30 days to respond. I'm going to take this another break again while I drink my beer. Yes. Subscribe to this channel. I'm trying to get to 1,000 subs. I'm almost there. 70 away. 70 away. All right. Back to the case. Where was what line was I at? Fiduciary duty. Defendant breaches fiduciary duty by we read that. We're at 51. Defendant breached his fiduciary duty by the plaintiff by refusing to allow plaintiff to review financial documents associated with the non-sequitur show in violation of the law. Yeah, that's everywhere. If Steve can prove they had a general partnership and this agreement, yeah, he should have gotten them. Yes, I think 51 is a damn good claim. I would definitely make that claim myself. Defendant breached the fiduciary duty to the plaintiff by refusing to provide the plaintiff with a formal accounting of the non-sequitur show. Again, in violation of North Carolina law. Okay, again, right. I think it's right on the money. Plaintiff has been damaged in the amount to be proven at trial. Okay, so they don't have an amount as a result of the defendant's breach of the fiduciary duty. So in other words, she's going to ask the court, this is how much do you think this is worth? In addition, plaintiff damages are ongoing and increasing due to the defendant's continuous operation of the non-sequitur show without the plaintiff, and due to the plaintiff's continuous collection of profits, depriving the plaintiff of previous contribution to the non-sequitur show fan base. But there's a lot going on here because Steve has been telling people not to watch the show, and the fans. So that's a complicated piece. Question from the chat, Nate Broady. So I guess that means Steve already knows how much money Kyle's supposed to give him. No, he's just throwing out this. He's probably throwing out numbers, trying to figure out how much. 25,000, 25. So it seems like he's throwing out amounts no less than $25,000 is what it's reading. So I don't think he knows. I think he's putting out these amounts and hoping one of them hits. But it's more than 25,000. Steve, he assumes it's more than 25,000. Okay. Going on. The fifth claim for relief. Wow. Unfair and deceptive trade practices. Can you guys read this? Let me make sure I didn't push this up too far. Yes, good. The allegations contained in the paragraph above incorporated reference there. All right, this is the same thing that's always read. The defendant engaged in unfair or deceptive conduct by virtue of the fraudulent conduct. Are we going to be talking about the whole the search engine optimization again? With respect to plaintiff's conversion of funds, which the plaintiff is entitled to, and his multiple breaches of fiduciary duty pursuant to the existing partnership. Again, he's saying we had a partnership that has to be proven at trial, has to be proven that they had a partnership. All these things have to be proven. He's saying them, but they would have to be proven at trial. And he's giving us little tidbits here, but this part, the agreement, the partnership, the terms, you got to lay all that out. You can't just say it. It's got to be something there. Now, Steve, I think, is going to get on the stand and say, yes, all this is true, but Kyle gets on the stand and says, yeah, all this is false. So this is really a mess in that sense. Maybe they have some communications, text messages, all that type of stuff to prove it, but right now I just don't see any of that stuff. All right. We're going to 56. Let me make sure. Don't put it up too high. All right. So the defendant engaged. We read that. The defendant's actions and conduct were in or affecting commerce. Okay. Maybe that's something that's needed in North Carolina. The defendant's unfair and deceptive conduct harmed the plaintiff in pursuant to this North Carolina statute. Plaintiff is entitled to recover compensatory damages in the amount exceeding $25,000. Steve, they love that number. To have such damages trebled, that's triple damages. Boom. And to recover attorney's fees pursuant to, so Steve is asking for attorney's fees, but this is a good segue to what I call the American rule. See, if you're in Europe and you're, maybe in Africa or even South America, in the American system, our system, it's you pay for your own legal fees and you pay for your own, unless it's something so crazy and your case is so frivolous that, hey, you wasted the court's time, you're going to pay the other guy's fees too. So it's a real uphill battle to get attorney's fees in the United States. It happens. It does happen. It happened with Trump versus Stormy Daniels. The court just found that case was so stupid that, you for wasting his time, you pay his attorney's fees. So here, he's asking for this. Steve is asking for this. And Steve is asking for this based on this unfair and deceptive trade practices. So it's going to be, it's interesting. It's interesting. All right. 6th claim for relief. So damn, so we're at the 6th claim for relief. 59, we're going to 60 on alternative. So he wants quantum merit. And what this is, simply put, I worked and I should get paid, right? Plaintiff performed his duties as co-host and as partner for the business relationship created between himself and the defendant. So look at number 60, because I think 60 is really important. In the alternative, if and to the extent the agreement is found unenforceable. So what this is saying is that if the court looks at this and says, hey, listen, your verbal agreement is BS. You don't have a verbal agreement. You know, it violates the statute. You know, there could be many reasons why there's no agreement. Unenforceable. We don't know what the terms are. Unenforceable agreement. Whatever the court finds. Steve's attorney is now saying, well, if you find we don't have an agreement, at least give us this, because he actually worked and he should get paid for work. So he's saying the plaintiff's contribution to 62. Plaintiff's contribution to non-sequitur shows publicly and financial success are valuable to the defendant, which is true. At the time of performance, plaintiff reasonably expected to be paid. It was reasonable for him to be expected paid for the value of his contribution to the show's profitability. So it's saying, you know, even if you find that there's no contract, it's reasonable to think that this guy thought me working in the show 4 or 5 every how many times he worked the show, he was reasonably expected to get paid. Now, this is going to be an interesting piece, because then you have other co-hosts to the shows too. Did they reasonably expect to be paid too? Because now you got the Susie Q's and the Goddess Engineers. Were they getting paid? Did they expect to get Mr. Atheist? You know? Yes, it's an argument. It's an argument that can be made. The time reasonably paid for value. 64. Defendant voluntarily accepted the benefit of the plaintiff's contribution, yes, to the non-sequitur show, knowing the plaintiff expected to be paid for the same. I think this is true, you know. And again, this is the last resort. Like, shit, if you don't give me the any of this other stuff, if you don't give me the partnership, if you don't give me the agreement, at least pay me for the work that I did. And here, 65, the defendant failed and refused to pay the plaintiff for equal portion. Plaintiff has been damaged by the defendant's failure to pay the amount in excess of $25,000 to be deemed at trial. So in other words, I'm going to prove it's going to be more than $25,000 we're going to do it at trial. If this is it. All right. Next claim, 7. So we're at page 8. This is crazy. And listen, if you've sat and through, if you're here right now listening to me go through this and you're enjoying this, you better hit that subscribe button. You do me right now. Do me right. I'll take a sip of this beer. I think I need another beer. So let's see if we can get through this. Nate Broady, I'm bored. You know what, Aries? This guy. All right. 7th claim for relief. Unjust enrichment. Now, if you guys watch my videos, you'd have seen my video on contract law where we go through particular theories of contract law. So, if you look through this complaint, the first theory of contract law that Steve is asking for is what we call bargain theory. He's saying we have an offer, we have acceptance, we have consideration. That's the gold standard of a contract. If you have that when contract law, you can get the most amount of money and the most amount of damages. But in the alternative, if I can't get bargain theory, you argue restitution theory. Restitution theory means I did the work and I should get paid for the work. You know, that's restitution theory. Generally, that's what Steve is asking for with this unjust enrichment. He's asking for, Kyle has been unjustly enriched by my work, and I should be compensated just for the work that I've done. So this is the end of the thing. Hold on. I hit twice. Funny. All right, so here we go. Line 68. So now we're talking about unjust enrichment. So now understand, this is Steve having to explain to the court why he should get paid because because Kyle was unjustly enriched by his work during the non-sequitur show. So 68, Kyle acting as co-host on the non-sequitur show and contributing to the non-sequitur show's non-sequiturs public publicity and financial success, plaintiff conferred a benefit onto the defendant. Again, this is restitution theory or unjust enrichment. Defendant accepted the benefit conferred by the plaintiff. So this, now when we talk about unjust enrichment, an example that comes to mind is, let's say you walk outside and you see a dog, and that dog leg is broke. You take the dog to a vet, you fix it up, you pay $5,000. Then 2 weeks later, you're walking the dog, and the true owner sees you with the dog and says, "Hey, that's my dog." And says, "You have my dog, thank you." And you say, "Well, it took me $5,000 to fix this dog's leg." And the person says, "Well, too bad. So what?" So, and then you sue that dog, the owner, the true owner of the dog, and you say, "Hey, listen, I want my $5,000 back." That dog owner now has been unjustly enriched. They get the benefit of having a healthy dog that has his leg all mended, and I'm out $5,000. So just give me back my $5,000. What I put into it, just give it back. I don't want anything more. I just want my $5,000 back. And that's what Steve is asking for here. It's more or less a last-ditch effort to get any type of funds from this particular action, if all else fails. So 69, defendant accepted the benefit. 70, plaintiff did not participate in the operation of non-sequitur show as a gratuity. So in other words, it wasn't a gift, but with the expectation of receiving payment for doing so as a partner in the business endeavor. So here he's still trying to throw in there, we were partners, but at this point, if we're really looking at this, the partner stuff is done. You're just looking to get paid for work. Defendant has been unjustly enriched. His college has been unjustly enriched by the value of the plaintiff's contribution to non-sequitur show's publicity and financial success by retaining the entirety of non-sequitur's proceeds. And that's true. Plaintiff has been damaged by the defendant's failure to pay in the amount of excess of $25,000 to be deemed at trial. So he's saying, if all hell is broken loose, what I did for the 2 years is worth over $25,000, and just, paid me that much. So we've read this. So now this is what Steve is asking for. We read this. So I'll just go through it one more time for those of you who are just joining us now, who haven't subscribed. You should be hitting that subscribe button. So this is what Steve is ultimately asking for. As we've heard, Steve is asking the court to enter a judgment against the defendant for actual damages incurred by the plaintiff, which is the breach of the agreement and 50% of the financials. That's what number one is more or less saying. He wants the money for the breach of the agreement and the amount calculated pursuant to the financial documents. 50%, give us the Patreon, give us all those documents, cut it 50%, and that's what I'm owed. Number two, he's asking for the plaintiff, for Steve to be reinstated at the primary ownership rights to the channel. Now, that I think, he would become 50% owner if the judge or jury agrees that they had some type of agreement and they're partners. Then he would be not primary ownership, but he would get 50% ownership of the channel. Number three, plaintiff's relief in the amount of excess of $25,000 on the claim of fraud. So he's asking for the $25,000 for fraud. Award the plaintiff compensatory, and he wants those triple damages in the amount of excess of $25,000 for the unfair and deceptive trade practices. An alternative, award the plaintiff's relief on the claim of quantum merit against the defendant. So in other words, so you remember those claims? So he's going down and saying, award me this for this one, this for this one. So we should see one we haven't seen one for conversion, and we haven't seen one for unjust enrichment. So that's the two things. So enter a judgment against the defendant for reasonable attorney's fees. So you got attorney's fees in there. Cost and fees to the defendant for the maximum allowable work, and provide such other relief. So, the court deemed just. So he didn't ask for the quantum merit. No, he did ask for quantum merit. He didn't ask for the conversion. He didn't ask for unjust enrichment. So he didn't ask for any relief for that. But, I think number 8, which is, I put that in all my things, all my legal pleadings too. It's the catch-all phrase, just in case you forget something, you got it there. So that is it. Submitted on the 23rd of August by Scott Myers, C. Scott Myers, North Carolina Bar. So that is the complaint. Interesting stuff. So what do you guys think? Do you guys think? Let me look at the chat real quick. See if there's anybody saying. So this is wild. So what do you guys think? Do you guys think Steve is asking for? It seems like he's asking for about $75,000-$80,000 on these different particular accounts, but it seems like he's asking for more than $25,000. I don't know. I don't know. It's complex. I think Steve has left out some very, very important details. I keep knocking this thing. The most important detail is the fact that he asked Kyle to hold the money. He asked, am I wrong with this? Somebody in the chat put it. Am I wrong? Didn't he ask Kyle to hold the money at one point? And only asked for it back in, recently, like a couple of months ago when they first had the fallout in June. So, I don't know. Maybe I'm wrong. Maybe I'm just misremembering. But, and there's a lot of details that seem to be out of here. So, people have been asking me for the link. So what I'm going to do another video about my top 10 questions about the Non-Sequitur show. Giving a quick breakdown. I'll put this, I'm doing that tomorrow, and I'll put this, the link to the documents in there. I do have the documents anyway. 75 grand in perpetuity. So, and I'll put that, and I'll see if I can update this one too with the link. And if I do, I'll let people know in the next video. So the question of the day, what do you think? Now I think this is a well-pleaded complaint. It goes through the motions. Now we all know this is what Steve is telling the court. This is why I should get, and I think Kyle does have some defenses. One thing that we are definitely going to be doing is, well, let me see. I'm thinking I should hold that for you next. You know what? Let me see. Put 1 if you guys want me to show you how to get the documents now. Put a 1. Or should I put that in another video and force you guys to watch me do it in another video? All right. Seems like everybody wants to see this in another video. All right. I see the ones. All right. So let's do this. Let me go and show you how to get the documents for yourself. Now, there are a lot of documents up there. And I am actually going to put this link in the chat. Should I put the link in the chat? Well, if it's a public record, I don't know. Sorry, Mr. Atheist, I'm sorry. This is public documents. I don't know how this would be doxing. Even though I understand the concern, but these are public records. Anybody can look them up. And that's what I'm about to show you guys now, how to look up the documents so you guys can also keep looking at what's going on. If somebody feels this doxed, I'm sorry, but these are public records that are available on the court's website. So now how we got this, that was funny because I was having a conversation earlier with a friend of mine, and we were like, let's, see what's going on with the Non-Sequitur show. So we looked it up and we found it, and I was like, oh shoot. Actually, I made a phone call too down there, and I was like, yo, what's happening with the case? And they're like, oh, it may not be up, but then it was up. I'm just right now looking for the link, and I am monologuing to myself like crazy because I'm just trying to find it. Come on. Here we go. All right. Now I'm going to type this into the chat. All right, here we go. Let me put this on screen so you guys can see it now. Okay, so this link will actually be in the description bar of this particular video. I'm going to move this over so you can see. This is the North Carolina court system. This is their document. So any case that you have in North Carolina, you can see here. And what I'm going to do is I'm going to put this link in the description bar after I finish this so you guys can see it. So how do you find these documents? So you go to the link. It's going to just say New York NYC Courts. Here we go. So the first thing you do is you come over here to this side where it says search, and you type in the name McRae. You press go, and you see it brings up here, McRae v. Curtis. You click this, and you'll see it comes up. The case comes right up. Oops, sorry. The case come right up. I want to make sure you guys can see this. On this side, Curtis v. McRae, then McRae v. Curtis. And up here, where it says case participants, you can see the information, where the case is at, the judge. And right here, where you see docket, this is all the court documents. So when Kyle files his response or his answer, you're going to see it right here. It'll come up, response, answer, so forth. So, and when you click on this, for instance, here's the complaint. When you click on the complaint, it brings up the complaint, and you can download the complaint or print it out, whatever you want to do. You can also get updates about when the case happens. So it also lets you know who the attorneys are and all this. So again, this is public information on the state's website about this particular case. So that's all we have. Mr. Atheist is saying I'm doxing Steve. Mr. Atheist, I hope you subscribe, man. I hope you subscribe to the channel. You're just going out throwing out I'm doxing people. I'm just messing with you. Just messing with you. It's a joke. It's a joke. It's a joke. I do want you to subscribe though. That's not a joke. So now, if you guys, let me do this so I'm not a liar. I'm going to put this in the chat right now. So I don't want you guys to think I'm BSing you. And I want you guys to go have some fun on the court's website. I know they're going to be like, damn, we got so much traffic all of a sudden. Copy this link, and it will be in the chat when I can find it again. Here we go. There it is, in the chat. Let me put it in the description too. Nate Broady, I wanted to know if you think that Steve has doxed Kyle by directing people to his address. Yes. Yes. 110%. Yes. That is doxing. That's harassment too. That's a problem. I think maybe the authorities should be called. If you're telling people to go to somebody's house, that may be criminal. And I think that should be reported to the authorities. If you're telling people to go to someone's house, and you're giving out their address, not only have you doxed them, you're harassing them. Nate Broady, if Kyle took over the administrative access before the videos were revenue. It's an interesting question. I'm not sure though. And Nate Broady. Oh, that's not what you meant? I'm sorry. So you maybe, let me see. Want to emphasize again, I don't believe you doxed him. If Kyle took administrative access. I don't know, I missed. Sorry, I wanted to know if you think if Kyle doxed by directing people to his address. Yeah. Oh, I'm sorry. I thought that's what you meant. Sorry. So, you guys have now been totally informed. You guys now can follow the case by yourself. You guys have the link. You guys have all the information. And I'm about to get out of here. So, again, before you go, if you want to see other videos about the evidence of fraud, about whether either one of these people are credible, any of that other great stuff that I've been doing, click on that playlist for the Non-Sequitur show. Come back to that tomorrow. Come back in a couple of days. I'm going to be doing the follow-up to this video, looking at the defenses and some other stuff, and then I'll also be doing some other legal stuff. If you haven't, be kind to subscribe, and I want to thank you guys again for watching, and I'm going to see you guys next time. But before you go, I do want to ask everybody who's watching a question. What do you think about this complaint? How do you think about the wording? I think it's well pleaded. I think it's interesting. But do you think Steve is actually going to win this case? It's really iffy right now because how do you know what the terms of the agreement are? Everything that we're doing now, we have to just trust Steve's word about it. And again, we haven't even known how Kyle has responded. So, hopefully if Kyle does respond, we'll get to see that, and then we'll have this next video about how Kyle responded to these allegations. Now, he doesn't have to respond to each allegation. He just say, I deny all allegations, and I'll see you at trial. But maybe he'll have a nice structured response so we can look at it. So, if anything, I will holler at you guys later. Thanks again for watching. And my name is Nate Broady. Don't forget to hit that subscribe button, and I will talk to you guys soon. Peace. Cue the outro.